The legality of deportations under the Alien Enemies Act. On March 12th of 2025, President Trump issued a proclamation invoking the Alien Enemies Act that all Venezuelan citizens 14 years of age or older who are members of the TDA, the Tren de Aragua, which is a transnational criminal organization from Venezuela, are within the United States and are not actually naturalized or lawful permanent residents of the United States are liable to be apprehended, restrained, secured, and removed as alien enemies. This follows his executive order from January 20th of 2025, in which he declared a national security emergency posed by international cartels and transnational organizations involved in what he called a campaign of violence and terror throughout the Western Hemisphere. And he directed the Secretary of State to designate these cartels and organizations as foreign terrorist organizations or specifically designated global terrorists. On March 15th, 2025, a class action lawsuit was filed by multiple Venezuelan men in immigration custody, asserting that the act does not provide the president with the authority to remove Venezuelans from the United States. The Alien Enemies Act of 1798 provides the president with extensive powers to order the detention and deportation of foreign enemies. It was originally passed when Congress believed a war with France was imminent. The act states, whenever there is a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the President makes public proclamation of the event, all natives, citizens, or other subjects of the hostile nation or government being of the age of 14 years and upward, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. There were only 3 periods in American history when this act has been used by presidents. The first was when President James Madison detained British citizens during the War of 1812. In early 1813, his State Department issued an order by which enemy aliens residing or being within 40 miles of tidewater were required to retire to such places beyond that distance from the tidewater to a place designated by federal marshals, and the marshals were authorized to arrest the enemy aliens who did not comply with the order. Charles Lockington, a British alien residing in Philadelphia, sued, and a Pennsylvania court concluded that he was lawfully detained. Another case, U.S. v. Thomas Williams, made it up to the Supreme Court, and the court found that Mr. Williams' detention was not proper because the marshal had not assigned him a place to which he was to report. However, this case was decided on technical grounds of Mr. Williams' detention by the Marshal of Virginia and did not consider the constitutionality of the Alien Enemies Act itself. The second proclamation involving the act was during World War I. On August 6th of 1917, President Woodrow Wilson invoked the act to restrict the conduct of German aliens and provided that an enemy alien who violated any regulation or of whom there is reasonable ground to believe that he is about to violate any regulation duly promulgated by the President could be arrested or placed in internment camps. He later expanded this order to include citizens of Austria-Hungary as well. Here, too, the judiciary deferred to the president. In Ex parte Franklin, a federal court considered Willis Franklin's lawsuit. Franklin was a 19-year-old who immigrated to the United States from Hamburg when he was 4. The court held that under the Alien Enemies Act, the discretion is vested in the president to determine the manner and degree of restraint to which alien enemies will be subjected, and although Franklin had lived in Mississippi for 15 years and had no memory of Germany, the judge pronounced him a German alien enemy, concluding that he did not believe that the action of the president, exercised in the manner provided by law, is subject to review by the courts. The third instance came after the Japanese attack on Pearl Harbor during World War II. President Franklin D. Roosevelt invoked the act against aliens from Japan, Germany, and Italy. vesting the power of arrest, detention, and internment of alien enemies deemed dangerous to the public peace or safety of the United States by the Attorney General or the Secretary of War. The Supreme Court in Ludecky versus Watkins upheld the president's authority to remove German aliens under the act even after the war had ended. In response to Mr. Ludecky's due process challenge contesting the constitutionality of the act, the court held that the act was almost as old as the Constitution itself, and it would be audacious now for the court to find the statute offensive to some emanation of the Bill of Rights. The court also held that it did not have the power to disregard the president's determination that aliens continued to pose a danger in the aftermath of the war, and thus the plaintiff had no right to judicial review of the Attorney General's determination that he was dangerous and subject to removal. In a subsequent decision from 1950, the Court of Appeals for the District of Columbia noted that executive power over enemy aliens, undelayed and unhampered by litigation, has been deemed throughout our history essential to wartime security, and that a resident enemy alien is constitutionally subject to summary arrest, internment, and deportation whenever a declared war exists. Courts will entertain his plea for freedom from executive custody only to ascertain the existence of a state of war and whether he is an enemy alien. Once these jurisdictional facts have been determined, courts will not inquire into any other issue as to his internment. So now let's return to Trump's reliance on the Alien Enemies Act. President Trump's position stretches the act further than it has ever been used in the past. His executive order from January asserts that international drug cartels functionally control, through a campaign of assassination, terror, rape, and brute force, nearly all illegal traffic across the southern border of the United States, and that they function as quasi-governmental entities and threaten the safety of the American people and the security of the United States. Now, the novelty of his position is his claim that the presence of aliens associated with these cartels may be deemed to be engaging in an invasion or a predatory incursion, which would give him the authority under the act to target them. Judges in New York, Colorado, and Texas have already ruled against Trump's use of the act to deport Venezuelans. In April, the U.S. District Court for the District of Colorado stated that the text of the Alien Enemies Act fundamentally demand military and wartime action, and the President's proclamation makes no finding that satisfies these definitional demands. Thus, to the extent the proclamation relies on the Act's invasion and incursion provisions to justify its removal powers, it does so improperly. In May, the U.S. District Court for the Southern District of Texas held that the historical record renders clear that the President's invocation of the AEA through the proclamation exceeds the scope of the statute and is contrary to the plain, ordinary meaning of the statute's terms. And in June, the U.S. District Court for the Western District of Texas ruled, under the Alien Enemies Act, a president cannot unilaterally define what constitutes an invasion, summarily declare that a foreign nation or government has threatened or perpetrated an invasion or predatory incursion of the United States, identify alien enemies subject to deportation or removal, and summarily remove them. The issue then progressed to the appellate courts. The U.S. Court of Appeals for the Fifth Circuit issued a decision on September 2nd, finding that the president lacks authority under the Alien Enemies Act because the Venezuelan mass illegal migration does not meet the definition of either an invasion or a predatory incursion. The U.S. Supreme Court has not ruled on whether Trump's use of the Alien Enemies Act is constitutional, but it has held that his administration must provide the aliens with notice and a chance to challenge their deportations. In May, the Supreme Court blocked Alien Enemies Act removals, finding that the aliens were not provided sufficient enough notice prior to their deportations. Justice Brett Kavanaugh wrote that the Supreme Court should consider the core issues directly, stating that the circumstances call for a prompt and final resolution, which likely can be provided only by this court. The Trump administration also wants to see the Supreme Court issue a direct ruling. Acting Solicitor General Sarah Harris put it this way: "This case presents fundamental questions about who decides how to conduct sensitive national security related operations in this country. The Constitution supplies a clear answer: the president. The Republic cannot afford a different choice.